Good evening. Today we're going to discuss about the Texas Service Center horror stories of how long the receipt notices are taking to adjudicate the EADs and adjustment of status. We're going to discuss about Charlie Oppenheim's departure in the State Department, what consequences we're expecting, what changes we're expecting in the State Department. We're going to also discuss about, with the COVID still being around, a lot of consulates not functioning, can we expect a spillover going from the family immigration to business immigration in the coming year, which is going to be 2023, starting in October 1st of 2022. My name is Rahul Reddy. Along with me is my business partner, Reddy Neumann. Emily, what do you speak about Texas Service Center? It takes 4 months sometimes just to even receive a receipt notice. Once we file the application, though, it used to take 4 months, 3 to 4 months, 2 to 3 months actually, to get an EAD approval once we file. Now we have gone to a stage where it's 4 months to get a receipt notice. What's going on with Texas Service Center?
Yeah, obviously October 2020, for some reason they weren't prepared for it or didn't prepare properly for it. The majority of the downgrades plus 485 filings went to the Texas Service Center, and they're just languishing there. At that time, it was taking months to get receipt notices. We're still in that same situation where you file an application now, and 4 months later, you're still waiting for just the receipt. Even the check is not getting cashed for months. Some of the checks expire before.
Unfortunately, not our office firm. Our office firm doesn't, but some of the checks expire in 3 months.
And so, of course, this is a problem for EAD renewals, where we've been talking about, the great thing about the green card EAD is if it expires while the renewal is pending, you get the automatic extension of 180 days. Well, at least you need a receipt notice to prove that you filed it. So what do you do when you have that gap period and you still don't have even a receipt? There's no filing fee for the EAD,
check cashing
so you can't even verify if they've actually received it. Or if you filed an adjustment of status and the priority date is retrogressing, or one day they decide they're not going to accept the filing date and you're still waiting, wondering if yours has been accepted, it's very stressful just to find out if your application has been filed. That's just the beginning of the problems. And we have I-140 still taking forever. People that filed their downgrades October 2020 were in December 2021, over a year. Downgrade I-140 is still pending. 485s are, of course, taking forever. EAD AP, that's the simplest thing you could possibly approve in all of immigration for employment base. It's, do you have a pending 485? That's it. And did you file an I-765? There's not even a filing fee. What are they doing taking so long to issue a simple EAD?
According to their own statement, it takes less than 15 minutes to adjudicate the EAD and advance parole. For that, they're taking 4 months to just accept the application. I think so it's time for us to call the Congress and inform them about the delays. Maybe ask for the resignation of these people. If you are so incompetent and you can't even function, get out. The Texas Service Center director should resign from the position, because if you can't function it, let other people do it, the job. This is the most dysfunctional service center that I ever existed in the history. Very, very ridiculous to have such dysfunctional service center director there not doing. We understood, okay, in October of 2020, they were not prepared. What about October of 2021? It's been 1 year. They still could not correct it. I think so. We need to inform. We have put some drafts there for you to write to the congressman. Please keep writing to the congressman, because last year they wasted 60,000 green cards. Thanks to all of our efforts, all of your efforts, that instead of 100,000, 60,000 were being wasted, 40,000 were being used. But this year we do have more number of green cards that are available. Instead of last year we had only 230. This time we have more than 260,000 green cards. So we have extra 40,000 extra green, 50,000 extra green cards, Emily. We have seen that in the first 3 quarters, they've only adjudicated about 85,000 green cards though. But in the last quarter, they adjudicated the 95,000 green cards. Now, the pace that I saw in the last quarter, that is July, August, and September, I don't see the same pace right now. So it is definitely that the Texas Service Center need to improve. I've seen definitely the National Benefit Center is doing a very good job. Nebraska Service Center is okay, but Texas Service Center is the worst. Even Tim Cook, the Apple CEO, has commented on Texas Service Center delays. So it's time for us to contact the congressman to make sure that these Texas Service Centers functional to an extent where it doesn't become a horror story for the legal immigrants. Any other suggestions that you have for that?
Yeah, I mean, why are we still filing so many applications at the Texas Service Center? We don't have a choice where to mail them, but they should be transferring them to other service centers. We're seeing cases where we get receipts from the National Benefits Center, which is great, and then they transfer it to Texas, of all places, and their transfer notice says for, to improve processing times or to create more efficiencies. That's complete nonsense. There's no reason that they should be transferring more work to Texas when they can't even handle what
they have introduced this interview system that is delaying Emily. We have seen spouses, if one couple is filing an adjustment of status based on each other, the files are getting separated. Sometimes only one person is getting approved, the other person is not getting approved. I don't know. This mess has never been like this. The last time I remember was that this was before Bush era. That was in Clinton era that I've seen. I've never seen this kind of mess though. So hopefully by writing the letters, we have seen the USCIS act upon the draft letters that we have sent it. They have commented on the Twitter. They have improved in the last quarter of the 2021, which ended in September 30th of 2020 though, because in the first 3 quarters they didn't move that much. In the last quarter they did adjudicate it. So we want you guys to keep the pressure, contact the congressman, contact the ombudsman. The drafts of them are already provided there in the links there. Please keep contacting and touch base with them so that we get the proper thing on it. Emily, now we have Charlie, who's been the director of the visa services from past 41 years. I mean, all my life that I've been practicing immigration law, he's been there. What do you expect the changes though? Because he is definitely responsible for not moving the dates properly and wasting the 60,000 green card last year.
Mm-hmm. Yeah, we don't yet know, as far as I know, who his replacement is going to be. But I would expect that it's going to be someone from within the State Department, probably someone from within his team, because they've been exposed to how he works for so long, which means that it's going to continue the same as what he did. I don't see them bringing in a breath of fresh air, someone from the outside who can look at everything and say, why are you doing it this way? You need to change everything. I think it's going to be more of the same.
I mean, we have a common law countries that we call ourselves as United States, England, Australia, Canada, India, and all these countries. When you look into all other common law countries, Emily, normally the top positions are held by bureaucrats that get transferred every 3 years. Why not we have the same system in the United States where fresh blood, fresh people come in and try to change that? Because when you look into the civil services of the other common law countries, the head of the department changes every 3 years. We don't have that. We had like this guy from 41 years.
Right. Yeah, I guess stability is one thing, but at some point you need some fresh ideas, some changes to be
We haven't got the visa bulletin yet, Emily, for the January month. Do you expect any changes coming in? Because when I looked into the data of the USCIS that has been released, they have 288,000 applications pending by the beginning of this year though. But yet they haven't moved the priority dates that much, a little bit on the EB2 factor though, but do you expect the 290,000 to be adjudicated by the end of this year? Do they have enough applications to adjudicate though?
Yeah, so I mean, we definitely have enough applications pending, especially when you take into account the consular processing applications, which are higher than they've probably ever been with so many people stuck outside. I think, part of the thought pattern is, well, we have all year to process all of these applications, so what's the rush?
Does it mean that I'm going to sleep all 9 months and work only in the last 3 months?
I don't know what they're doing. But yeah, as far as upcoming visa bulletins, I think in the last check-in with Charlie, he explained that yes, EB2 India, he pushed it forward just to see how much of the upgrades from EB3 back into EB2 would be generated, but that they wouldn't know how many actually are generated until several months later. So it sounded like he was going to slow down that EB2 forward movement to see what happened with the October bulletin, and then possibly in April 2022 would be the next time we might see more aggressive movement, depending on how much was generated by that earlier movement.
But I'd see that if they don't have enough applications, this month is the month that they should open up so that they can adjudicate the applications by end of this year, Emily. Let's see if the new captain that we have, which we don't know who it is, will bring in some new ideas, new innovative ideas, so that none of the employment-based immigration green cards will be wasted. But be prepared to write letters to the ombudsman, to the congressman, to the USCIS director too, to make sure that they are functional and they don't waste any of the green cards. Emily, now the coronavirus is not dead. It's somehow, spreading around one form or another. We all thought that it died, then the Delta variant came in, then they call it as Omicron or whatever it is, and consulates are still not fully operational. I would say that they're operational only 25% at this point of time. And most of the family immigration happens in the consulate though. Last year we had 150,000 extra green cards that fell in to the business immigration. Do you expect the same thing coming in 2023, which starts on October 1st, Emily?
If you'd asked me that in October, I probably would have said no, but now we're October, November, December, 3 months into this fiscal year, still operating at these low levels. That's 3 months worth of immigrant visas for family-based cases that are probably not being processed. So unless things drastically improve at the consulates and they start approving all kinds of applications in the fourth quarter like USCIS did last year, there's a good chance that we will have more spillover depending on what Congress does, because in the Build Back Better plan, if I recall, they were not eliminating the spillover, but basically preventing the wastage, so then there's nothing to spill over. So the family would keep whatever got wasted this year, and the employment base would keep any that might be wasted this year. So we'll have to see how that impacts us as well.
Questions are coming, Emily, with regards to the Build Back Better America. What's the stage? Where is it right now?
Yeah, so we're still stuck with the parliamentarian, and no news on when a decision is going to be made. No news on really what provisions have been given. Everything's just kind of happening in a black box. What we do know is if this is going to happen, it really has to happen within the next 2 weeks. And that means we have to get the decision from the parliamentarian that is in our favor in terms of the employment-based immigration provisions. Then we have to have the Judiciary Committee of the Senate actually draft the bill. There's still no drafted bill. These are just kind of proposals that are flying around right now. So we have to have them draft the bill, make whatever amendments they're going to make, put all of the different committee sections together into one big bill, have the Senate actually pass that, and then it might be different than what the House passed. Now we have to go back to the House and try to come together in a conference and get it passed and get it signed all in 2 weeks. I don't know. I don't have high hopes, but maybe now, the Senate today, I believe, passed the debt limit increase.
Ceiling.
So maybe that was a bit of a stumbling block, and now that that's done, they can move their efforts towards this bill, but it needs to happen quick.
Why does it have to happen quick? Why can't it happen next year?
Yeah, so technically it could happen next year, but realistically, next year's an election year. Everyone's sights are going to be on re-election. No one's going to be touching any hot topics. They don't want to make any waves when they're going through re-election, sadly.
Question from Savarkar Duraiswamy. Working more than one W-2 after green card is approved, is it acceptable? Absolutely. My wife gets W-2s from 6 to 8 companies though. She's in the healthcare field, and that's normal in the healthcare field. People do work for different companies though. Nothing wrong with IT field also. People work for different companies. Nothing wrong at all.
And Nan from YouTube mentions that his spouse was able to receive a duplicate I-539 approval notice after contacting the USCIS Ombudsman Office, which is great because normally they've been telling us to file an I-824, which is
taking 2 years.
2 years to process, and an additional filing fee for something that they should have just issued. So thanks for updating on that. Glad to hear it worked out.
A question from Natural Yogi. If the RFE response is 30 days, do we still have the 60-day extension? Yes, as of today, I don't know the exact date. I think so it's up to January 30th. It may be even, but as of today though, if you have received the RFE today, if it says 30 days, you have an automatic 60-day extension. It's there. You don't have to do anything. You don't have to request them. It's automatically there. You can have it. You can see that in the website of the USCIS also.
Rakesh wants to know, is it advisable to refile if the priority date is current in both EB2 and EB3, but the downgrade application is stuck at the Nebraska Service Center? Well, one of the reasons to refile is if your EB3 date retrogressed and now you have the option of filing an EB2, which is different from your situation. So obviously we have a lot of things that are to be taken into consideration, the extra cost of filing a second 485. You're now at the back of the line in terms of processing times. You may have to do the biometrics again. You have to get the photos again. You have to do the medical exam again. And you might do all of that and your file might be transferred to the Nebraska Service Center because your other one is pending there. So there's no guarantees that filing that second application is going to be beneficial, especially where the date is current in both. It's really just a judgment call because no one can predict what ultimately will happen from here. USCIS is just doing crazy things and they can do whatever they want with these applications. Unfortunately, we can't really advise which way is the route to go.
Can you file a green card application F1 OPT? Questions from Ankit Datta. Yes, absolutely you can, especially for the people who are not Indian nationals though. We skip H1B completely. We feel that H1B is a waste of money for them. We can get them the green card EAD before you even get them the H1B. Yeah, for Indian nationals also, it is definitely a good option to go for the green card while you're on OPT.
Srikanth wants to know, if I need to travel to India while my H4 EAD is pending, will it impact the H4 EAD? So if it's just the EAD by itself, as in you already have H4 status and now you filed the EAD application or an extension of the EAD, you can travel while that EAD application is pending. It doesn't have any impact. You just had to be in the US on the day of filing. If it also includes an H4, so where you filed an H4 extension and filed the EAD along with it, we have seen a few situations where after you travel and you get the visa stamp and come back in, sometimes they'll administratively close that H4 extension because you already got the H4 at the consulate. You don't need the extension. Well, that administrative closure could lead the EAD to be denied because the H4 application that it was filed with wasn't approved. So there are slight risks. I've only seen that happen in just a handful of cases, but it's something to consider and maybe refile the EAD application after you return in H4 status just as a backup plan.
Surendranath Vasa from Facebook has this question. Do you think that the immigration provisions will pass in the Senate? That's definitely a billion-dollar question, Surendranath. I see that 90 Congress, the House of Representative members are emphasizing that they should ignore the parliamentarian whom we did not elect and should have the immigration provisions as it is what they passed in the House though. It depends on how much pressure we all put it. I see a lot of people having rallies, having a lot of efforts done. Now, because of that, Senator Durbin seems to be putting those people's agenda in front of the Senate though. But when it comes to the business immigration, we are not yet clear whether they are putting it in the Senate, they're not putting it in the Senate, they're not disclosing the information though. So definitely we would like you to write letter to the Senator. This is the time. I can tell you one thing, Surana, that if the immigration provisions are not put in this bill, it's going to be very unlikely that the provisions that passed in the House will ever get passed in the next 10 years. So either now or never. That's the way I am feeling. Any disagreement? Absolutely. Yeah. Because for these provisions to pass in the Senate though, then it would require 60 votes, which we don't have it. And there's also some speculation that this, the next Congress may not be Democratic Congress. I meant to say about the House of Representatives. So at this point of time, we do have House of Representatives and Senate. We don't have 60 votes, but we do have 51 votes. If this goes through the budget, though, it only requires 51 votes. But if it doesn't include in the budget bill, what will happen is that then it would require 60 votes. If it doesn't have 50 votes, where are we going to get the 60 votes? So if it doesn't pass through right now, it may take ever, maybe not in your and my lifetime, so not.
Hidayat wants to know, my wife's I-765 got approved today and we filed together. Do they approve them together? Is there going to be a delay in mine? Oftentimes, I would say the majority of time, they do approve them together, but lately we do see a lot of cases where one application gets approved for one family member and others are still pending. So there's no guarantee that they will be approved together. No guarantee that that yours will be delayed as well, but either one could happen, unfortunately.
My case was outside my normal processing time. I created a service request, contacted the ombudsman, nothing happened. Any suggestion? You may consider court litigation. That's one thing that you may consider. If you want to consult, you can contact Stephen Brown in our office. He's very good in these things to advise you whether it's worth for you to go to the court litigation.
Sam wants to know, can I interfile medicals even if my priority date is not current in the final action date chart? So interfiling is, there's no time limit for it, no time requirement for it. It just means that you are sending something into USCIS after you have filed, before they approve it, and it's something they have not yet asked for. So there's no rules on what you can send and when. Anytime you need to send something into them that they're not asking for right now, you can do it. But when will they actually get it into the file? Will it be useful to do it if your final action date is not current? That's a different story, but can you do it? Absolutely.
Chetan has asked this question, when would the premium processing for the EAD regulation be implemented? What will happen in practice? Can they take it back? They can suspend it after they pass the regulation. It is supposed to happen, but it didn't happen, Chetan. I don't know when it's going to happen. I would strongly recommend to contact the Ombudsman and USCIS director on that one to implement this as fast as possible. This is nothing to do with Congress, though. This is just an administrative process. So the regulation could be issued. The USCIS can suspend at times when they feel that they are not capable of implementing those things. We have seen that, especially in the I-140 and H-1B. In sometimes they do suspend it. I can tell you one thing, Chetan, is that once they implement this provision, though, most probably they like the money. I mean, that's $2,500. It's going to be very hard for them to forgo the $2,500. We have seen in some instances, especially on the H-1B, when initially filing at the time of quota, they suspended it for a while. For the I-140, especially for the EB1C category, they suspended because of some tactical reasons they have. But for advanced parole, for H4, for the EAD though, for the EAD and H4 though, I'll be very, very surprised if they would suspend it once they started.
Dr. Krishna wants to know, can a Canadian citizen get the H4 stamping done at the land border, or do I have to book an appointment at the consulate? So Canadian citizens are generally what we call visa exempt, which means you don't need a visa stamp in your passport in order to travel into the US. Instead, at the port of entry, you request admission to the US in H4 status based on the fact that your spouse has an approved H-1B. So this can be done either at a land port of entry when you're driving in, or at a pre-flight inspection facility at one of the airports in Canada, or even sometimes if you're landing into the US, you do it at the port of entry here when you land. But you don't have to have an appointment at a consulate.
Rahul has this question. His existing EAD and AP is in the renewal process, just came back from India. Do you want me to file the advance parole again? The rule is a little bit different, Rahul. I want to explain to you that. If it's an initial advance parole filing, we would recommend that you refile the advance parole again. If it's an extension which is pending though, you not need to file the advance parole again. Nikhil has this question. My company was being acquired by a bigger company What do I need to do with my H-1B visa? Nikhil, it depends on it depends on how the acquisition happened. If the new company is a true successor of interest with regards to the liabilities and assets of the H-1B though, then they may not need any amendment for you. They may use the existing H-1B for you to continue on that. If the corporate changes are more significant, it may not meet the successor of interest, then they may need to file an amendment before you join the new company. So it will depend upon your HR. HR will be able to, HR and your company lawyer may be able to guide better. But if you want outside people's advice, you by yourself should not go to a lawyer, because we would require the information from the HR to see how the acquisition is happening. So either you can go to the company's lawyer and you can have an outside lawyer speak with your company's HR to make sure that whether or not you would require an amendment or you don't require an amendment.
Manasa has a question on a derivative changing the employer after the 485 is filed, and wants to confirm that the 180-day rule only applies to the primary application. So if the derivative who's an H-1B, can they change the employer if the 485 is pending for less than 180 days? Yes, for the derivative, there is no 180-day rule. You can change employers the day after your 485 is filed when you're the derivative, and assuming you have employment authorization and file the H-1B transfer. No 180-day rule applied to derivatives for job changes.
Emily, a lot of people are confused with regards to if they have to wait after the I-140 is approved for more than 6 months to change the job, or is it only the 485 has to be pending?
Right, it's just the 485 pending for 180 days. So if the I-140 gets approved on day 179, on day 180 of the 485, you still can change jobs, which is the next day after the I-140 is approved.
Soham has this question. Do you see the EB3 advance in January visa bulletin? No, I'm not expecting EB3 though. If you're thinking that if it's going to cross January 1st of 2015, definitely not. Definitely not. I may expect to see the final action date a little bit movement from EB3 also, but definitely I'm not expecting the filing date to move beyond January 1st of 2015 though. Unless some miracle happens and the Department of State comes to the reality that the USCIS is not going to adjudicate, and they come to the reality, then we may expect something. But in general, I'm not expecting.
Prasuna received an EAD in September and is planning to change employers and submitting a 485J supplement. His son turns 21 in November of 2023 and wants to know, will there be an issue with him converting to F1 if I've changed employers on the EAD? Possibly, yes. So if your son is a derivative of your non-immigrant status, let's say you are in H-1B status and your son is in H-4 status based on your H-1B, when you convert to EAD, your son is no longer in H-4 status. You need to have your son remain in H-4 status up till the time they file the change of status to F1 to be able to successfully convert from H-4 to F1. Your son cannot convert from AOS, pending AOS, or an EAD to F1. So he needs to be able to continue the non-immigrant status until the time of filing that I-539. So you may not be able to use your EAD until after that point.
Emily, I'm not a little bit updated on this Dropbox. I know for sure that the 4 years expiration after the visa expires, you can apply with the Dropbox in India. If the previous stamping has been done in India only, you can apply up to 4 years. That's only available until December 31st of 2021. I know it's not available after January 1st unless they extend it. But after January 1st, is it 1 year after the visa expires, or is it 2 years after the visa expires?
Good question. If I recall, before COVID, it was 1 year.
And then
they extended it to 2 and then they extended it to 4.
The 4 one expires on December 31st.
Yeah, so if we're going back to the original, I think it would go back to the 1 year because the 4 replaced the 2.
Yes. So yeah, it should be, be careful guys if you are planning to go on the Dropbox after January 1st of 2021. 2021. Just to update that, we have seen some openings in the Delhi Consulate in March of 2021 and some of the other consulates also. There are definitely not been reported of any openings before March of 2021. We do expect though that this 4-year rule of visa stamping most probably Dropbox will be extended even after January 1st. But there is no announcement at this point of time. We will let you know if there is an announcement that comes in.
Geary had an H-1B extension filed in June. The green card was issued in November, and then the H-1B extension was denied, and wants to know, is that employment between June and November unauthorized because of that H-1B extension denial? No, it's not. So assuming that your H-1B extension was timely filed and was not a frivolous filing, that pending extension automatically provides work authorization for up to 240 days based on the pending extension. That automatic work authorization ends on the day of the denial, but it's not retroactive to when your prior H-1B expired.
Question from Sanjeev Ranjan from Facebook is that his prior date is 2016. What do you expect in the next 3 to 4 years in EB2? My parents are getting US citizenship next year. Could they sponsor me and my wife? One thing is that if we are expecting more spillovers next year, there is a good chance that things may move forward for the employment based for the Indian nationals though. Now, when your parents are becoming US citizens, though, they can sponsor you and your wife, but the date is backlogged for that, for Indian nationals, until August of 2009 as a filing date, and also and 2008 as a final action date. So definitely you seems to be much better in the employment based rather than family based. But I do advise though, if your parents become US citizen, let them file an I-130 application. There is something called F3 visa that will include you and your wife, the married son and wife, the daughter-in-law can be applied in F3 category. They can throw an application, it doesn't harm, it doesn't conflict anything. You never know if something moves, some changes occur maybe. So definitely I would advise that let them file an I-130 application. But yeah, 2008 prior to date to 2016, you definitely are well better off in EB2 at this point of time, or EB3.
Anik wants to know, can you file for the green card while on F1 OPT?
I
You already answered that one.
Prasad has asked a question. If you travel to India while the transfer is pending, what will be the impact on my travel? If the H-1B is transferred, he can still travel. Is that right, Emily? When the transfer application is pending?
Assuming the other prior H-1B is not expired.
Not expired, is traveling. But the problem is, how are you going to come back into the country? Because you don't have the H-1B approval of the transferred company. So the best thing would be right now to file a premium processing, get the H-1B transferred, then come back. Because when you're coming back, you have a receipt notice. You don't have the approval. You're telling that you're working with this company, but you don't have the approval from USCIS. You're telling CBP to allow you to come into the country. Definitely not advisable.
Srikar wants to know, have you seen any new EB2 MSC 485s getting transferred to TSC because the old EB3 485 is at TSC? Yes, we have seen this happen. So these are cases where a second 485 is filed at one of the lock boxes. From their lock box, it gets transferred to the National Benefit Center to be receipted in. So they get the receipt notice from National Benefit Center, which is MSC, and then a few weeks later, the 485 gets transferred to the Texas Service Center. We've also seen the EAD and AP applications remain at the National Benefit Center. I've heard rumors of people who then later the case was transferred back to the National Benefit Center from Texas, but I've not seen that happen in any of my cases yet.
Yeah, I've seen some cases where they didn't transfer, Emily, but I've seen some they did transfer though. It's kind of hit and miss. We don't know how it's going to work out, but there's no guarantees just because you have the National Benefit Center receipt notice that it's going to remain there. There's no guarantees for it. I don't understand the logic for them to transfer it. They should have transferred the other way around because that would have been better. National Benefit Center is way ahead of the Texas Service Center.
Mohammed wants to know, please comment on the proposed bill, American Tech Workforce Act of 2021 by Representative Jim Banks to eliminate STEM OPT and reduce the H-1B to a 1-year period. Well, I would say he's probably up for re-election, and he's probably in a district that is very conservative, and he's doing this for purposes of getting re-elected. I don't think it has any chance of going anywhere.
There'll be almost like about 50, 60 immigration legislation pending. Most of them are just to appease their constituencies to get re-elected. They know that seriously that doesn't have any chance of passing. So I don't want you guys to create a fear based on what this particular bill is. So please, ignore it. It's not worth looking into it. These kind of bills that are there.
Mayur says, can a dependent switch from H4 EAD to 485 EAD while the H4 and H4 EAD extension is pending and then switch back to the H4 EAD when it gets approved? Well, once you use the 485 EAD, you're no longer in H4 status. So I think that even though the H4 and H4 EAD will probably get approved because USCIS doesn't know you've used that 485 EAD, I don't think you can use them because you're no longer in H4 status. You're instead in adjustment of status. You have to go out and come back in H4, and then you could utilize the H4 EAD.
Emily, can they go to Mexico and come back instead of going a H4 stamping and coming back because that can avoid the stamping?
Exactly, yeah. So once you get that H4 extension approved with the I-94, even though it's technically not possible to do because you're in AOS now, you can exit to Canada or Mexico for less than 30 days, come back in using your old expired H4 visa stamp plus this new approval notice, use automatic revalidation to get back into H4 status, and then you could start using the H4 EAD.
These questions are coming very frequently, guys. If you are married to the adjustment of status, there are two ways you can get it divorced. One is that, of course, you can go outside the country, get the stamping, and come back. A lot of people are asking question, Emily, hey, I applied for the green card. Can I still get the H-1B and H-4 stamping? Because my intention has now changed.
Mm-hmm. Yeah, the good thing is the H and L visas are both dual intent visas, so they do allow you to be intending an immigrant as well as applying for a non-immigrant visa at the same time. So no issues with that.
Yeah, and then also when you're trying to go to Mexico and you're trying to come back on showing the H-1B and H-4, it's practically you're getting divorced from the adjustment of status and getting back to the non-immigrant status though. You may want to consider, do you actually need to do all these things though? Unless you have intention of refiling the 485 application, I don't know why you have to do all these things. I personally, when I was in adjustment of status, I got married to the adjustment of status. I don't have the conscience to tell all the other people, hey, you maintain the non-immigrant status only to make immigration lawyers rich. Because that serves the immigration lawyers. Because I personally, when I was in adjustment of status, I used the EAD and let my H4 go. So I don't have the conscience to tell you guys to just keep on using the keep on maintaining the non-immigrant status. Now there are exceptions though, especially age-out kids are coming. If there is any criminal history, if there's a very deficiencies in the I-140 or H-1Bs, there are some bad things that went on with them, then probably I would say about 5 to 10% of them may fall into the criteria, but 90% of the people, they don't fall into the criteria of maintaining non-immigrant status and the EAD though. Now one cautious thing that I would say that do not get married until your I-140, underlying I-140 is approved, because that's something that is very crucial. There is always a chance there. I want you to get the I-140 approved.
Premanand has the AOS filed in October under EB3 when the date was current, but did not get a receipt notice for his daughter. What can be done? The FedEx tracking confirms the delivery. So yeah, we definitely see receipt notice delays, but for one filed in October, I'm assuming October of this year, I think you have a couple of steps to take. Number one is to email the lockbox support. They're taking forever to get back to you, and usually they don't get back to you until after you finally get the receipt notice, and so you don't need their help anymore. The next thing would be to contact the USCIS Ombudsman Office for assistance with that to verify that it has been received and properly filed. But yeah, a lot of people are in that situation with just the delays in receipts. You don't have a way to confirm whether it's just been filed properly. That's very difficult.
We have this interesting debate that I want you to participate in. The question comes from Mohan from YouTube. He's asking a question that if he has an advance parole, he goes to the visa stamping. If it gets rejected, do you see any problem in his coming on the advance parole? I personally think that it depends on the reason why the rejection happened, though. I would definitely recommend that they contact an immigration lawyer before they come in.
Yeah, I would agree with that. You know,
what about if there is a 221G and they withdraw the application, they come in?
Yeah, I think if it's just administrative processing, you probably could do that. But if it's something that's denied, the visa's rejected due to fraud or misrepresentation, that might open up another ground of inadmissibility that applies to the advanced parole entry.
Too. Yeah, sometimes, maintaining the non-immigrant status in the EAD may have 7% risk, and maintaining of EAD only without non-immigrant status have less than 1% risk. Choose your options. One which will benefit the immigration lawyers more, one that will benefit you guys more. Question from Vishal Bendri. Can I move 485 process to my own company? The company that he owns.
Under AC 21, yes, absolutely.
I personally, though, Emily, I would like to avoid the circumstances, though, because I see more scrutiny at the USCIS office. The officers don't understand the process, and I know that we have been successfully represented in the clients, explaining to the officer that it doesn't require that the owner has to be different. But I would like to avoid the circumstances, but under force, though, where they don't have any option, then I would opt them to go with their own company.
Chemlesh applied for an H1 extension along with the H4 and EAD. The H1 has been approved. Of course, the H4 and EAD are still pending, and now has another job offer and wants to know, do I need to reapply for the H4 and EAD along with the H1 transfer to the new employer? Technically, no, but practically it's a good idea. And the reason for that is sometimes when you transfer to the new employer, the old employer withdraws your approved H-1B. That H-1B is tied to the pending H-4 and EAD. Although it's technically not tied to it in the legal sense, what happens is the officer, when they finally look at the H-4 and EAD, they see the withdrawal of the H-1B and they just automatically deny the H-4, which causes the EAD to be automatically denied. Now, yes, that's a wrongful denial, because what they should have done is send an RFE asking for proof that the H-1B holder continues to maintain status after that H-1B was withdrawn. So you can file a motion to reopen, and it should be successful in getting the H-4 and EAD issued, but how long is that going to take? It's going to add another 6 months to a year to the processing time. So you may be better off, go ahead and file it again anyways. Better be safe than sorry on that.
Any updates on Nebraska Service Center, like approvals per month with receipt duties processing right now? No clue. I mean, there is nothing called first come, first serve basis in the USCIS that exists today. That's the reason we put the title, the mess up, the horror things that are going on in the service centers for the legal immigrants in the United States. No first come and first approval. It depends on the officer who got it. If he is familiar with the case, he may approve it faster. It depends on his workload. It depends on his ethics. It depends on him completely. Question, if the dependent, sorry, you go ahead.
Minu wants to know, is there a way we can follow up with USCIS SAVE verification for driver's license renewal? It's been a month and still waiting for the review status. Unfortunately, none that I'm aware of. Now, you can track the status. You can create your own account with the My USCIS Save system and track and see when it updates to show that the process has been complete. So you know when to go back to the driver's license office, but to actually check with them what's the cause of the delay and it being outside normal processing time, there's nothing like that for the Save verification.
Anup Patel from YouTube has this question. Can my son go to college on H4 or does he need to move to F1? He can definitely go to college on H4. I personally, myself, when I was on H4, I went to the college. It was not an issue. I mean, I went to the college on H4. So yeah, your son, I mean, I was a spouse, still I went to the college on H4. Your son also can go, but you need to make a note that your son will be kicked out of the H4 when he turns 21, unless he is in adjustment of status and age is locked out, where you don't have to worry about moving on F1. Because at 21, they will be kicked out of the H4. You may want to file an F1 application when they are 19 and a half. That's the ideal time that I would recommend you to file F1 visa.
Harsha was in the U.S. on F1 and got an H-1B approved and then traveled outside the U.S. I'm assuming this was a change of status that was approved to H-1, but then you traveled, lost the job, got a new job, filed a new H-1B petition, but now can't find any visa slots for the H-1B stamping. Can I request for an NIE or emergency appointment? So the NIE technically no longer exists because that was only a way to get around the COVID travel ban. So since those have been lifted for most countries and the H-1B travel ban no longer exists, what you need is an emergency appointment. And the process for that is first book your regular appointment whenever it happens to be the earliest you can get. Once that's booked, there's a button to click that says request emergency appointment. And then you fill out a form that explains the reason for your emergency appointment. In a situation like this, it would typically be due to business needs of your U.S. employer. They need you back to work in the U.S. So it's helpful to have a letter from the employer explaining the urgent need to have you back in the U.S. and you provide the same information in that request form. And then you wait to get an email to see if you've been granted an emergency appointment or not.
Question from Monica is that if the final action dates are not current, can we use the AC-21 after 180 days of filing the 485? Yes, yes, and yes. There is no rule that says that your final action date needs to be current for you to use the AC-21 and change to a different company. The I-140 approval definitely is a safety method that I have told you, but as such, there is no such rule, none, to have you wait until your final action date is current. Questions from Karuna is that what should I bring to the biometrics appointment? Her biometrics appointment is tomorrow. Your biometrics ID card, which is your driving license, if possible, your passport also. If you take these three things, biometrics doesn't have to be original, even a copy of the letter of that is good enough. And original driving license and passport, these three things are good enough. You are not speaking with technically an immigration officer, they're contract employees. They're only there to check whether you are the proper person and they are going to do the biometrics there. No interviews happening, whether you're married, your marriage certificate, your birth certificate, your 485 receipt notices, your H-1B approvals, nothing is happening there. They are just checking if you are the person and they are doing the biometrics there.
Rakesh has an AOS that's pending based on a previous employer where the final action date is current and wants to know, can his current employer apply for the H-1B extension using the previous employer's I-140? Yes, but it's only a 1-year extension once your final action date has become current. So you need to submit that I-140 approval plus the 485 receipt to show that you did file the 485 within 1 year of it becoming current. However, this is only if your labor certification was filed at least 365 days before you hit the 6-year limit. If you waited until into your 6th year before filing that labor certification, there's no extension beyond the 6 years once your final action date is current.
I'm answering the question from Murali. If your previous stamping is from Mexico, you are not eligible for the Dropbox stamping in India. For the Dropbox stamping, your previous stamping must have had happened in India only. It could have been any consulate in India. Question from Sai Nara. He wants an update of what's going on the premium processing. I'm assuming that I'm speaking about these downgrade applications. We have a significant amount of I-140 applications under the premium processing getting adjudicated right now though. Initially it was very less, but by this time, most of the cases that we filed, approximately 90% of the cases that we filed in premium processing will be accepted. We still have 10% of the cases we are refiling and refiling. It's happening. But if you have not filed a premium processing, please file the premium processing in Texas Service Center. If it gets rejected, keep filing it again, keep filing it again. You will get through mostly at one point of time.
I've had a couple of people ask, if you file that second 485 and you want to avoid it being transferred to the Texas Service Center, is it worth it to withdraw the first 485 that's pending at the Texas Service Center? I don't know if it's worth it.
I would not.
I don't think there's any guarantee that they won't transfer it to the Texas Service Center because you withdrew it. Number one, the withdrawal is going to take forever to process. And number two, they might still transfer it there even after you withdrew it because they want to verify the two
And then why do you want to
applications.
lose the line that you are there? You're spending all the money. I would rather go on 2 lines. Whichever comes first, I will go, because you never know that if EB3 will not advance and EB2 will not go forward though, go backward. So I definitely will not withdraw, Emily. Okay, and
Jagadish has a 485 pending for 180 days. The I-140 was only approved 4 months ago. He wants to know the risk of the employer revoking the I-140 petition. Will that deny the 485 reportability? So the I-140, the fact that it was only approved 4 months ago, doesn't matter because your 485 has been pending for 180 days. So you're still eligible for AC-21, you're still eligible for your 485 to be processed, even if that employer withdraws before the I-140 has been approved for 180 days.
where did these people got this 180-day rule for that the I-140 has approved?
I think it's from the 2017 regulation that added the benefits that you get for having your I-140 approved for 180 days.
Yes, and then
but prior to that, the rule was always, as long as the 485 is pending for 180 days, it doesn't matter what happens to the I-140. Then they added additional benefits to the I-140 being approved for 180 days, but that didn't get rid of the original AC-21 benefits of portability.
And Emily, this is also people are telling that you have to wait for 180 days to leave the company after you get the green card. Is there any truth in it?
Absolutely not.
And why not? Why is all the people telling that you have to wait for 180 days?
Well, if you can leave the company before you even get the green card, clearly they're not going to require you to stay with the company after you receive the green card.
There are so many articles that tell otherwise, Emily, which we tell you not to believe it. Please, as Emily has pointed out, she said, if you can leave the company before you get the green card, after the green card you can. Now, of course, if you leave the company before the green card, there are some regulations you need to follow. The next job that you should be taking should be in a similar profession, and the company should be offering a permanent job. But after getting the green card, you can do anything you want. You can be a Microsoft CEO, you can flip a burger in McDonald's, or you can be a lawyer like me and Emily. A lot of questions with regards to the people who are in the student visa, OPT or student visa applying for the green card. Absolutely. Especially if you, for the people who are not Indian nationals, we do a lot of them, guys. We do a lot of them. They don't need to get to the H-1B at all. Waste of their H-1B number, waste of the money, waste of the time, waste of the money that you pay to the immigration lawyers. Get the green card, get out of the way.
Monica asks, is the AOS application filed under the filing date chart also eligible for AC-21? Absolutely. No issues at all.
Gulam is asking, people are asking questions with regards to how long it's taking right now for the POM processing. They're adjudicating the cases filed in June and July of 2021 right now. That's the time. Prevailingly, it's taking about 4 to 6 months. The total processing time to file the POM labor certification may range depending on how much advanced the company's recruitment process is. It may sometimes take to 2 months, but if they're starting from the scratch though, it may take all the way to 8 months to just file a POM application. So be prepared that if you're joining a new company though, the time process it takes for you to get the entire thing may be approximately 1.5 years for you to get the labor certification approval.
Sunil wants to know what needs to be done for the H4 EAD auto extension when the H4 and H4 EAD applications are pending. So to qualify for the auto extension, you need to have the EAD application filed before the current EAD expires, and you need to have an H4 I-94 that is valid beyond the date that your EAD expires. So if you filed the H4 and EAD together, I would assume that your H4 currently is not valid beyond the date the EAD expires. So your option is to exit, go for stamping, assuming your spouse's H-1B has already been extended and approved. Go for stamping based on your spouse's H-1B approval, come back in. Now you have an H-4 I-94 that's beyond the EAD date, but it only helps you for 180 days. So if it takes you 180 days to get the visa stamp, then it doesn't really do you any good. But we do still have another class action lawsuit ongoing for trying to improve the H-4 and EAD processing times. So we know that the auto renewal isn't perfect. It doesn't help that many people, but it was kind of a stepping stone to get to the next lawsuit.
Answer to the question, Ahmed Danani, that just because you're an Indian national, it doesn't prohibit you to apply for green card if you are on student visa or OPT. Absolutely, you can. Indian nationals also can file green card when they're in OPT. Sneha Mehta, the GC holder is planning to travel for India for 3 months. So does the CBP ask whether you work for 3 months abroad for a US company? They can ask the question. The answer is it doesn't matter. In the 3 months, you never work for any company, neither in Indian company nor US company. It doesn't matter. They cannot prohibit you coming into the United States. Even if you work, you don't work, you work for the US company or you don't work for the US company. That if you're coming in 3 months. If you're coming after 6 months, I definitely recommend you to contact the lawyer, but within 6 months, you're absolutely fine. You do not have any problem. Question with regard, you go ahead.
Sen wants to know if the primary applicant received the green card, but the dependent received an RFE, what is considered to be the dependent's priority date? When will it get processed once the RFE is submitted? So even the dependent has the same priority date as the primary applicant. So as soon as that RFE response is submitted, assuming your priority date is still valid, then they will process according to first in, first out, and the priority date being current. So technically you're right, they don't have their own priority date, but once the 485 is filed, everybody's priority date is the principal applicant's priority date.
Gulam has this good question. Suppose I-94 is about to expire, already filed the 485, and they are not filing the extension of the I-94. Will it be considered that they are staying legally in the United States? Gulam, I'm assuming that you're speaking about the dependent though. Yes, absolutely, they are staying legally. So if the H4 is expired and they are not filing the H4 extension, they're perfectly all right. The same case is for H1B also, but there is one caveat. If the main applicant doesn't have the work authorization, if the EAD is approved, it's not a problem. They're maintaining legal status. If the EAD is not approved, they can still stay in the United States, but they cannot work. The main applicant, they cannot work if the extension has not been done.
All right, well, I think we are out of time for today. Thanks so much for joining us. We'll be back again next Tuesday at 5 o'clock.
Thank you.